Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, my law partner. David, welcome.
Thanks so much, Michael. Always a pleasure to be here with you.
Thank you. So today's program, let us start with the cutoff dates for the month of April 2014. Now for the family preference categories, the first preference, which is for the unmarried sons and daughters of U.S. citizens, advances by 4 weeks to February 1, 2007. For the family 2A category, there's no movement, which is the 2A categories for the spouses and children under the age of 21 of green card holders. Date remains the same, September 8, 2013. The family 2B category, which are the unmarried sons and daughters over the age of 21 of green card holders. It's a good movement. Advances by 7 weeks to September 1, 2006. The family third preference, which are the married sons and daughters of U.S. citizens, advances by 4 weeks for all the countries to June 15, 2003. The family fourth preference, which are the brothers and sisters of U.S. citizens, married or unmarried, advances by 2 weeks to November 8, 2001. Now the employment preference category.
Michael, before you go on to the employment categories, could you just repeat the family first preference again?
Yeah, the family first preference is for the unmarried sons and daughters over the age of 21 of U.S. citizens.
Right, and what was the movement for?
It's 4 weeks.
3 weeks?
Yeah, to February 1, 2007, 4 weeks.
Okay.
Okay, hold it, stop it. She may give it wrong. Why did she send? This is the wrong one. She's stupid. You have to do it again.
You see what I'm saying?
Yeah. She sent March and separate April. Why did she send March, Okay, let's start again.
She didn't know. She when you said send March, she was thinking, I'm sorry, I should have told you that.
No, it's good. No, otherwise we'd have made a wrong mistake.
Yeah, that's, yeah. So
glad you
sorry about that. Yeah, start again. Yeah, please.
Yeah. Hello, viewers. Welcome to our program on immigration and you. I am your immigration attorney, Michael Fulwani, and once again, we have with us attorney David Nachman, my law partner. David?
Thanks so much. Thank you, Michael. Pleasure to be here with you always.
Okay, so today's program, we're going to start with the cutoff dates for the month of April 2014. In the family preference categories, the first preference, which is for the unmarried sons and daughters over the age of 21 of U.S. citizens, advanced by 3 weeks to February 22nd, 2007. The family 2A category, which is for the spouses and unmarried sons and daughters under the age of 21 of green card holders, no movement, date remains the same, September 8, 2013. The family 2B category, which is for the unmarried sons and daughters over the age of 21 of green card holders, advances by 7 weeks to October 22nd, 2006. And the family third preference, which are the married sons and daughters of the U.S. citizens, advances by 4 weeks to July 15, 2003. And the family fourth preference, which are the brothers and sisters of U.S. citizens, advances by 2 weeks to November 22nd, 2001. Now, the employment preference categories. The first preference, which is for the priority workers, is current for all the countries. The employment second preference, which is for the advanced degree holders, is current for most of the countries except India. India, unfortunately, no advance movement. Date remains the same, November 15, 2004. The employment third preference, which are the professionals and skilled workers, for most of the countries except India, advances by 4 weeks to October 1, 2012. Unfortunately for India, no advance movement here also, and date remains the same, September 15, 2003. Same thing for the other workers category, all other categories except India, 4 weeks to October 1, 2013. And for the India also, there's no advance movement. Date remains the same, September 15, 2003. Unfortunately, as you can see, employment preference categories, none of them advanced from the last month. So that's a bad news in a way. The fourth preference is special immigrants, which includes religious workers and priests and all that, is current for all the countries. And the employment fifth preference, which are for the investors of $1 million or $500,000, is also current for all the countries. Now, there is some kind of feeling that going forward in maybe a few months, looks like the prediction is that there may be a cutoff date for the EB5 categories because there's a lot more interest and applications coming in. I think weren't they talking the same thing about employment first preference at some point may establish a priority date?
Mostly, I think the EB5, I've been reading about the possibility of a cutoff date because of the large number of Chinese nationals who are taking advantage of the EB5 classification. But Michael, I think that this is probably a good time for us to mention that anyone who obviously is feeling pressure from the long waits in the classifications should consider the possibility of cross-chargeability, which means that if you're married to an individual from a different country, if you're an Indian and you have significant backlogs and you're married to someone from Bangladesh or Sri Lanka or one of the other countries, then of course they don't have backlogs, so you can use cross-chargeability to take advantage of that. And also what it does is it takes us to the issue of immigration reform, and that is that, right now, Michael, I'm sure you're going to discuss this, is that, immigration reform is back on the front burner. The House of Representatives is talking about the possibility of advancing H.R. 15, which is the new bill in the House, and they're thinking about doing a special type of procedure to advance that the bill out of the House of Representatives. And if that happens, of course, many of these priority date backlogs and issues will become hopefully something of the past.
When you say that happens, you are basically talking about the Senate bill that was passed by the Senate. Is the same bill that they are, more or less, that HR
right, HR 15 was the mirror image in the House of Representatives. And I guess what happened was the Pelosi got upset that it wasn't moving, and so what she did was she is seeking to invoke a special procedure to advance that bill through the House of Representatives.
Actually, they tried their best with the Speaker of the House to introduce the bill, and under the pressure of his own colleagues, the Republicans, he did not do that.
Correct.
And this is a good news in a way, but it still is uncertain as to whether House will pass it or not pass it. We just praying, we hope that the good sense will prevail upon our Republican House people, and senators already did it. And if that gets passed, inshallah, that is going to be the biggest thing for our viewers and all the people.
Exactly, and I think I'd like to point out to our viewers that we as immigration professionals, of course, take a very important role in trying to convince Congress that immigration reform is something that needs to be done. And this is April, and every year in April we have what's called the National Day of Action, where immigration lawyers from across the country go down to Washington, D.C. We convene on a Thursday in the middle of the month, and what we try to do is we speak to the congressional representatives themselves. We sit down with them or their representatives, and what we try to do is convince them how important immigration reform is to our nation as a whole. So that will be happening in the middle of the month.
So while we are on the same subject, let's talk a few minutes about what President Obama can do, because his frustration. I mean, I just read the newspaper today, a large number of Latino people, they don't want to even vote either for Republicans or for Democrats. And they are all very much frustrated with President Obama not putting hard work or being forceful in getting the bill passed. Right. So we were already talking about in the previous programs that it may be a good idea for the president to see what he can do with administratively. Remember that provisional waiver, that was one of the best things that he did. The DACA was another thing that he administratively did.
Exactly.
Like that, there are some other ways some other more of that. Of course, some people say he should simply say that people who are illegally in this country should not be deported. It's probably a large order. Probably he's much concerned about the opposition from the Congress, that he's bypassing the Congress. But smaller things. Let us talk about the children over 21 who are left out. Let's brother file for the sister, sister file for the brother, the fourth preference category. The brother, sister, and the spouse came in, but children crossed 21. And even with the CSPA adjustment, under which children who age out are still eligible, even that did not work. So there are a lot of those children who are left behind. Now the parent now files the petition for them. They are giving them the new priority date. The new priority date will be F-2B category, which is waiting are 7 or 8 years.
Right.
On this issue, we both know that some of the courts, federal courts, have held that in that kind of situation, when the parent files a petition under F-2B, he should be given the old priority date. Now, if I was a president, and I'm not, if I was a president, I will say that these are the decisions of the federal courts. And I think it is more appropriate for the administration to follow the court decisions and administratively adopt that policy. Because the court says the interpretation of the law. So it's nothing to do with the legislation. They say this is the way we interpret, and this is the right way to do it. Administration can say, yes, that is correct, we agree. And how about that? What do you say to that?
Well, I think that it's a difficult issue because there's so much politics involved. I mean, take a look at what's happened with the CSPA. The Supreme Court heard arguments many months ago on the CSPA, and they still have yet to issue a determination on that particular issue. And the reason that they're hiding behind is to say that, well, there are still administrative issues at play. So what you have is you have a battle in the political powers of our nation, and unfortunately, this is politics. And but I think that the president has a tremendous amount of leverage. He's already asserted that leverage. He's already allowed for deferred action for military families. He's allowed for DACA, which is not regulatory. It's actually a form of prosecutorial discretion. And I think what the president has clearly made, and clearly brought to the forefront is that he's going to do something if Congress can't act. And it'll be very interesting to see what it is that he actually ends up doing. I think the play by the Hispanic lobby groups is an interesting one because I think that they're not going to throw their weight behind either party yet until they figure out who's willing to move somewhere. I think that they're holding that out as a carrot in front of the horse, so to speak.
Yeah.
And what they're doing is they're waiting to see who's going to move on the immigration, and that's the carrot because they are such a powerful lobby. Okay, and they know they're powerful. So what they're doing is they're saying, we're waiting to see who's going to move, and then what we'll do is we'll throw our weight where the people move. Because if they throw their weight behind the Democrats, then what's going to happen is the Republicans are going to throw up their hands in the House and say, it doesn't matter what we do. If we don't do anything, we're still going to lose the vote. So I think that that's the carrot in front of the horse.
What you're saying, they should hold the carrot in one hand and move from one horse to another horse to see which horse is willing to bite that.
That's right.
No,
and I'm not calling our representative horses, but maybe other types of animals.
Seriously speaking, I personally think that President Obama has the discretion to administratively do that. But let us see what happens.
Absolutely. There's a tremendous amount of leverage there.
Now, what he has been doing basically, again, let's go back to this other issue of deportations. In the maximum number of people have been deported in Obama time, I have a number here. Until of this period, in the last 2 years, 2 billion people have been deported, the maximum ever under any presidency. And he was playing the game in the sense that by doing it, he will win the heart of the Republicans that yes, administration is doing what the best and the illegal immigration issues being resolved, and then come forward and pass the CIR.
Well, that's how he won the term or the nomenclature of deporter-in-chief. That's what they refer to President Obama as. And again, I think it's politics, Michael, and I think you would agree with me. What it's about is that President Obama, I think, has his heart in the right place with regard to immigration reform, but I think that what he's doing is he is trying to figure out what the middle ground is. And in order to keep people happy or to keep the Republicans happy, the way to do that is to increase the deportations. So what he's doing is he's essentially serving the cornerstone of the comprehensive immigration reform with one hand and hoping with the other hand that he's going to be able to pass the good provisions of the bill, which hopefully we'll see this spring, but it's anyone's guess.
But it's not happening. The problem that I have is not happening, and it's about time for the president to realize and come forward with the administrative process.
I absolutely agree, but the problem is that doing nothing is always an option.
Yeah.
And because doing nothing is an option, sometimes that's what Congress does.
Well, we are running out of time, David. A very interesting subject, and we could talk a little bit more about in the forthcoming programs. And we thank you very much for being on the program. And
Thank you so much,
all of you
Michael.
watching the program. Please keep watching us every Saturday and Sunday on ITV. Thank you very much and goodbye. The options.
Yeah, perfect. That's good.
Yeah, we get subject and extending that subject in different
Yeah, of course.
areas.
Yeah.
Program number 2.
Ready?
Yeah.
Okay.
Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman. David, welcome.
Thanks so much, Michael. Always a pleasure.
So I want to ask you a question. Now
Ask away.
that the H-1B season is over, by this time everybody who wanted to file H-1B has already filed it.
That's right.
And if it's not going to come, it's not going to reach within the quota that is allocated, or a person couldn't file, or person's lottery program comes, as you know about the lottery program, when the number of applications exceed the quota, then they do a lottery, random.
That's right.
And they pick up the ones that are processed.
Right.
So we are talking about the people who couldn't file, didn't file, or did not come under the lottery program. What are the options now? They have to wait one more year, obviously, for the next year.
Well, some people have to wait a year, Michael, but some people don't have to. I mean, the first thing that's most important is that H-1B season really doesn't end for us because we represent a lot of academic institutions throughout the United States, and we're doing H-1Bs all year. And what that does is it tells you that there are exemptions from the H-1B cap. And some of you might be exempt from the H-1B cap. Those of you who are getting jobs with academic institutions or government research organizations, those are exempt, or if you have a job that's affiliated with an academic institution or government research organization. And the definition of affiliated with is something that we really need to look at and analyze for your particular case, because organizations that you might not necessarily think are affiliated with academic organizations or government research organizations may in fact be. So that's the first thing. The next thing, of course, that we want to look at once you decide whether or not you have the H-1B exemption is, and this is a very important one, it's for people who have OPT, is do they have the ability?
Yeah. How do they find out whether this is a cap exempt or not? That's one question everybody will ask you when you say cap.
Well, the organizations usually know whether or not they're cap exempt. I mean, academic institutions are designated under a special provision of the law. It's a higher education law, and there's a special section of the law. I don't remember the citation right off the top of my head, but you can look it up and you can figure it out. Or, of course, the idea would be to come to a qualified immigration professional like ourselves or someone else out in the field and find out whether or not you can submit an exempt H-1B.
Right.
So that's number one. Number two is, of course, individuals who don't have the opportunity to submit cap-exempt H-1Bs, then, of course, you're in OPT, and if you didn't get H-1B, then, of course, you want to see if you can get a STEM extension. Now, there is a list that's available to international student officers, ISOs, at your universities. They're usually the ones to give you your extension. The extension is a 17-month extension. You're entitled, of course, to 12 months. Hopefully, you applied for the H-1B while you're still in work-authorized status. And then, of course, if you don't get that H-1B, fall back on the STEM extension. So again, seek a qualified immigration professional's assistance, including, of course, your international student officer who knows whether or not they can grant you the STEM extension. And they do so by signing your I-20, and also you have to make sure that the employer is enrolled in E-Verify. The E-Verify program allows the employer to take advantage of the STEM extension.
There are other options that if none of that is working,
Well, there are
there's a possibility of changing back to the F1. If they are OPT also, they can join some other course and continue to remain in, because they don't want
That's
to
right.
go back home.
They can go back and study. That's another option. Another option is to, we always ask the individual or try to figure out whether or not maybe they have a particular hobby. Maybe you can do an O-1B for them.
Correct.
If they're from Australia, maybe they have an Australian citizenship. A lot of our Indian clients have gotten Australian citizenship, so they can do E3s. And a lot of times they can also, if they're from Canada, they've gotten Canadian citizenship, they might be able to take advantage of TNs. But the bottom line is that each case is different.
Don't forget, J1 is also an option. J1 extension.
Yeah,
as
J1
long as it's not subject to 2-year condition.
Yeah, exactly. J1 is an option, but the problem that we have with J1s is that we never want to put someone into a J1 situation where they're going to become subject to the 2-year residency requirement, Section 212E of the Immigration Nationality Act.
That's what I said.
We want to look at that very carefully, because then there might be a different route you can go, Michael. Instead of the J1, you could take them to H3, and H3 might be a way to circumvent that 2-year residency requirement, which is really nice. But the most important thing for our viewers to know is that no case is not cookie cutter. The analysis is not cookie cutter. Everyone's situation is different. We need to look at the resumes, and we need to look at your particular circumstances to figure out whether or not you have an alternative to the H-1B non-immigrant visa classification.
And if somebody cannot remain in legal status because none of these things that we told about, it's not a bad idea that for a few months they can go back home and take a vacation.
Of course.
And then the H1 is still, even they're not here, H1 petition can be filed when the new year comes in. That is one option. Some people like this.
Exactly.
Okay, few more,
Exactly.
5-6 more months, just want to go home and take a nice vacation.
That's right, especially when you're talking about information technologies workers, because a lot of times information technologies workers can work remotely. So they don't have to be in the United States. They can go to Canada, they can go to India, they could go to Western Europe. So there are all kinds of options, and our firm is a little different than others, especially with regard to immigration, because we have Canadian lawyers on our staff who offer up Canadian immigration law options to individuals who can't make the H-1B cap. So if you find yourself in a position where you're kind of desperate, but you definitely don't want to go home, the Canadian immigration law option is one that you should definitely explore.
Let's not forget the marriage option also. Guys already.
Well, I like you a lot, but I don't know if we can do that.
Let's say the guy already 24, 25, marriageable age, already considering
Absolutely.
to get married.
Yep.
And then he gets married. Obviously, everybody knows that a person gets married to a U.S. citizen or a green card holder can apply for a green card. But even that is not happening. Let's say he finds is a man and finds a woman who is on an H-1 visa. And then he gets married to her, he gets H-4. He can continue to remain in U.S. on H-4 for a year. The next year come forward, he can always change from H-4 back to H-1.
That's right. He can be a derivative. Yeah. And I guess a lot of people have to realize that, when you take on that derivative status, that H-4 status, then of course the possibility exists that you can go back into the next cycle, or you can also study an H-4 status. So that's another option.
Exactly.
Yeah.
So let's talk about those of our viewers who have filed an H-1B petition. The employers have filed, obviously.
Right.
And there's an RFE.
Right. Request for evidence.
For the
Yeah.
evidence. So how complicated is RFE? What kind of work needs to be done to satisfy the immigration service and get the H-1B petition approved?
It's a great question, Michael. It's a really good question, especially now, because probably within either this week or next week, the USCIS probably is going to be starting to process a tremendous number of these premium process cases. I believe that they announced that starting on April 20th, they're going to start processing the premium processing cases. Those are not even the non-premium processing cases. So on April 20th, they're going to start processing premium process H-1Bs. So within about 14 days, you're either going to get an approval, a denial, or what's called an RFE, a request for evidence. Now, what is an RFE? An RFE is Again, a request for evidence is a term of the art for a query. We often hear our clients refer to it as a query, and those queries oftentimes will ask questions that are already included in the original petition, which is very frustrating for us as immigration professionals because we are answering questions that we've already answered, but we still have to provide the information. But generally, those questions are about, number one, is it a professional and specialty occupation? So oftentimes a person will submit a position, and the government will have a question as to whether or not a professional in a specialty occupation is really needed for that job. Maybe you can give an example. And the next thing I'm thinking is that oftentimes the government will come back and ask, does the business have the need for someone to perform those functions in a professional and specialty occupation for that business? So for example, let's say you have an employer who only has 5 employees. Do you really need to have a professional performing in that position? So that's another question that
But
they
that's
might
a
ask.
businessman's decision. He needs more, he needs
Well,
more.
yeah, and you would think that it is a businessman's decision, but the thing is the government is asking for you to prove that, in fact, the business needs to have an individual doing those functions, and for that person, of course, to be the person who is designated under the H-1B for that particular purpose.
Also, there may be also a issue raised for the applicant, the beneficiary, the H1 guy, with regard to this education. For example,
Absolutely.
they may raise the issue, if the person has a clear degree to degree, US degree, or a very clear degree
That's right.
from UK, some country, there's generally not that issue. But many times we know that people try to get equivalency based upon combination of education and experience.
That's right.
And the Immigration Service in some cases questions that.
Right. They'll come back and they'll question the academic equivalency. Sometimes if you don't use an academic equivalency, but you're using an academic plus experiential equivalency, because there's something called the 3-to-1 rule, where 3 years of work is equal to 1 year of academic training for a bachelor's degree. So if you use the 3-to-1 rule and you're combining your academic and your experiential, then of course you end up in a situation where they're going to question that too. So they're going to ask you for letters to prove that the individual's actually worked for the number of years that you're trying to prove the experiential
So what you are
credentials.
combining is orange juice to orange juice, not orange juice and apple juice.
Exactly.
For example, the person has a MBA, he has got a diploma in business administration, something like a 3-year course in India. And then the experience is like he's a salesman in a shoe store, right? So he said, I have 3 years of experience. Is that good enough? The answer is no.
Right, because it's not in...
It's a different
field.
It's not professional work.
Exactly.
It's a different field.
Exactly.
So that's also to be taken into consideration. Basically, when we file the petitions, first of all, let me go back to a question of why does the RFE come? Basically, experienced law firms like ours, we know what exactly is needed from the beneficiary, from the employer. All these issues we know. When we get lot of RFEs, we understand where Immigration Service is likely to come back and send an RFE.
Exactly.
So that the most important thing is that your first H-1B filing also should be done very carefully with full knowledge and understanding, and realizing that where there may be a weakness in the case that RFE may trigger.
Exactly.
And we take care of that weakness before the filing.
Exactly. We try to address the weaknesses up front so that we don't have to later circle back around and start answering those questions on an RFE. Our goal, of course, is to try to avert the need for an RFE, because unfortunately the RFE ends up costing us time and the client's money and time. And what we try to do is to avoid the whole RFE process if we can. Unfortunately, in many cases, we can't. We can't avoid it. So, but the key, if you're going to get an RFE, is to be ready to respond to the queries that the government asks. And I have to say, generally speaking, they are uniform. So we're used to certain questions that the government asks, and we're prepared to go back to our clients immediately and ask them for the financial information or the experiential or the academic information that we need to be able to respond quickly to that RFE. And the benefit, of course, to doing that is by quickly responding. Then, of course, if it's premium process, in 14 days you get a new turnaround.
And there are certain occasions where we get an opinion from an expert opinion in support of
Exactly.
realizing that
Exactly.
we need to put in something strong for the Immigration Service to accept and approve the case.
Absolutely.
With that, again, we are running out of time, sir. And thank all of you for watching the program. Please keep watching us every Saturday and Sunday only on ITV. And goodbye.
Thank you, Michael. Good, good, good. Sax on.
Ready for the next one, or you want a short break?
Give a little hot water. We'll continue. Just give me a little
We
water.
can, yeah, we can go. If you're up for it, I'm.
Little hot water, and then I'm going to go.
Okay. Do you have other stuff that, okay.
I'll talk about
rock
the
and roll.
select service.
The what, I'm sorry?
Select service. Select service.
Select?
For citizenship.
Select?
Select service.
What is that?
You have
Oh,
to-
select